Hi, this is Bill O'Leary, Legacy Planning Law Group here, and welcome to the Estate Settlement Program podcast series. This podcast is associated with Module 5 called Taxes, and in particular, the tax conference that you're about to have with your legal team. Now, you may want to invite your CPA or your tax return preparer, and maybe your financial advisor and any of the beneficiaries, maybe. If you're not the surviving spouse, you might consider inviting the surviving spouse. Keeping in mind again that if you invite others besides your legal team, that the attorney-client confidentiality may somehow be jeopardized. So now, with regard to the tax conference, there are two different types of taxes that we're mostly concerned about. The first type is one that you're probably familiar with, income taxes. Everybody has to file an income tax return called a Form 1040. Well, when you have an estate or trust administration, you have to file a tax return too. It's called a Form 1041. That's loosely called a fiduciary income tax return. Now, when all of the income is distributed out to the various beneficiaries, the trust or the estate usually doesn't pay any income tax associated with the income. Instead, a Form K1, it's called a K1, is made and distributed to the beneficiaries so that each beneficiary pays their proportionate burden of any income tax for the income that they received. When we're talking about income now, we're generally talking about things like interest and dividends, and sometimes we're talking about capital gains. Now, keep in mind that when the decedent passed away, when your loved one passed away, generally speaking, we receive what's called a step-up in tax cost basis equal to the value of the assets on the date of your loved one's death. And what that means is that the capital gain or capital loss that would be realized from the sale of the assets, it will not be based on the original tax basis, which is whatever the decedent paid for the asset, but instead it's going to be based on the date of death value of the assets, so that then if you as the beneficiary were to take that asset and sell it, or if it were to be sold as part of the administration, the only capital gains that would have to be paid would be the difference between the date of death value of the asset and whatever the selling price was. Now, what other income tax issues are there? Well, one of the types of assets that does not receive capital gains step up in basis is something called income with respect to a decedent. And that's a legal term, income with respect to a decedent. This includes things like traditional IRAs, traditional 401ks, pensions, profit-sharing plans, and so forth. So what happens here is that when a beneficiary of the inherited IRA or the inherited pension receives it and then makes a withdrawal, they're taxed on the income just as the decedent would have been taxed on the income had he or she made the withdrawal themselves. Now, spouses, of course, are the only ones who can roll over the inherited IRA or pension. They can roll it over into their own IRA. So one of the things that you want to be talking to your financial advisor about is whether, let's say you're the surviving spouse or there is a surviving spouse that's named as a beneficiary, whether a rollover should occur. Now, yet another item to talk about is whether the required minimum distribution has already been made out of the IRA account. So, for example, if the decedent was over age 70 and a half, which is called the required beginning date, that we all must begin taking distributions from our IRAs and 401ks, if the decedent was over that age, then we have to determine by the time that the decedent passed away, well, had they taken their minimum required distribution for the year? If they haven't, this is something that has to be done before we start setting up inherited IRAs and making distributions from IRAs and 401ks and those types of accounts. And oh, by the way, a new law just went into effect on January 1, 2020, increasing the distribution to age 72. One of the things we'll talk about in the asset conference is whether that has occurred or not. So we all know about income taxes. Well, the next kind of taxes that we're going to be talking about during our taxes conference will be estate taxes. Many estates don't have estate taxes to pay. So the issue will be whether we have to even file an estate tax return. Generally speaking, if the estate isn't a large enough estate under whatever the current federal exemption amount is, we won't be filing a federal estate tax return. But there are circumstances when the estates are larger, or when the surviving spouse wants to do something called portability. Then we'll file an estate tax return. So what's portability? What portability means is, well, let's say I have a $5 million exemption, but my estate is only worth $2 million, and I'm just using hypothetical numbers right now. Normally, I would not have to file an estate tax return, but let's say that the surviving spouse has $8 million in her own name. What is she going to do? Well, she's going to want the estate to file a federal estate tax return on my estate and claim my unused exemption as her own. So that means we could port it over to her, transfer it over to her. We can move it to her, to the surviving spouse, by filing a properly filed federal estate tax return that is timely filed. So sometimes we'll be filing an estate tax return. When we have the taxes conference, we're going to need values, what are called date of death values, for all of the assets, which we're going to need anyway to in order to determine the tax cost basis of those assets, to see whether a step up in tax cost basis is available. So when there's an estate tax return, there's going to be a different work involved than when we just have an income tax return. Now, if you look through the Estate Settlement Program Guide, Module 5, you'll see that there are worksheets both for income tax to help coordinate the income tax information that your tax preparer is going to need, and there are also worksheets for the estate tax information. So please use those worksheets, and if you have any questions about those worksheets, we'll bring them up at the conference that we're about to have. Finally, there could be state tax issues. Now, Florida does not have a state income tax, nor does it have a state estate tax. But we could be having an administration, or there could be assets, or there could be income earned in some other state that does have taxation. So where we have those items, we'll be discussing whether state tax issues are something we need to consider, and whether the tax return preparer will be filing any special state tax returns. So that's what we're going to be doing at the upcoming taxes conference. We're going to be talking about income taxes, talking about estate taxes, and in some circumstances, we'll be talking about state tax issues. So look through Module 5, complete as much of that information as you can, or at least review it prior to our meeting. And of course, we look forward to speaking with you soon.